The big story of the day, the Varanasi District Court, in a crucial order in the Gyanvapi case, has rejected the Hindu side's plea seeking carbon dating of the structure found in the wuzu khana of the Gyanvapi complex. The court in its order states that carbon dating of the purported Shivling may cause damage to it and will lead to a violation of the Supreme Court's order. Remember, the Supreme Court's order on the 17th of May in 2020 directed the DM of Varanasi to ensure that the area where the Shivling is slated to have been found is duly protected. With the Varanasi court dismissing their plea, the Hindu side is now planning to approach the Supreme Court to challenge the district court's order. Their contention is that scientific investigation to determine the age of the structure in question will help determine the nature of the same. The Muslim side, on the other hand, said that the order has been pronounced keeping in mind the religious sentiments of people.
उस एप्लीकेशन को माननीय न्यायालय ने रिजेक्ट किया है और माननीय न्यायालय ने ये रीजनिंग दी है क्योंकि सुप्रीम कोर्ट ने 17 मई के ऑर्डर से इस एरिया को सील कर रखा था। इसलिए अगर हम कोई भी ऑर्डर पास करेंगे तो वो उस ऑर्डर का उल्लंघन हो। तो मैं आपके सामने बयान देना चाहता हूं कि इस ऑर्डर के अगेंस्ट हम सुप्रीम कोर्ट जाएंगे। इस ऑर्डर को हम सुप्रीम कोर्ट में चुनौती देंगे। ये ऑर्डर अगेंस्ट द रिकॉर्ड है क्योंकि सुप्रीम कोर्ट ने 20 मई के ऑर्डर से ट्रायल कोर्ट को पावर दी थी कि वो सारी एप्लीकेशन डिसाइड करेंगे। दूसरी बात, ये मांग लेके हम सारे महिलाएं याचिकाकर्ता सुप्रीम कोर्ट गए थे और सुप्रीम कोर्ट ने कहा था कि आप ट्रायल कोर्ट को अप्रोच करिए। तो ट्रायल कोर्ट आज कह रहा है कि हम नहीं कर सकते क्योंकि सुप्रीम कोर्ट ने सील कर रखा है। तो हम इस मांग को लेके अब दोबारा सुप्रीम कोर्ट के सामने जाएंगे।
आम जनमानस की धार्मिक भावना आस्था को भी ख्याल रखते हुए उनकी कार्बन डेटिंग की एप्लीकेशन निरस्त किया है। कोई जीत हार की बात नहीं है, ये एक इंटरलोक्यूटरी ऑर्डर है। इसका मेरिट पे कोई प्रभाव नहीं होगा। मेरिट पे तो एविडेंस से तय होगी।
So what happens next in the legal fight? The Hindu side is all set to approach the Supreme Court, but there are other possible options as well that could be explored. They can seek a carbon dating of structures outside the area which has been sealed on orders of the top court, that areas in the vicinity of the Shivling. Experts are also of the view that Hindu side can request for other scientific investigation like ground penetrating radar, which is non-destructive in nature.
In fact, I was also expecting the same, something of the same sort of judgment from the court, because the rocks cannot be radiocarbon dated. The important aspect is that the nearby area can be excavated, say 2 by 2 meters adjoining the area of the Shivling or Shivling type of structure. And from that particular level when it was established there, if some carbon sample comes out, then that can be dated. So far as ground penetrating radar is concerned, I was the first person to use this in 1993 in Lal Court in Delhi. And then later on, it was also used at Ayodhya and other places by me and other colleagues. Here in this case also, it's a non-invasive method. It's non-destructive one. So it can be used here also. I believe it is a Shivling because it can't be a fawara or fountain. Nowhere such type of fountain has ever been found. The fountains which we get from the Mughal times, they are slender, and on the top there is something of a shape of a bird. Secondly, the water also is put inside the fountain with some pressure, and there is no pond or anything through which the water can come.
All right. right, joining us on the debate, we have a lawyer Deshratan Nigam. We also have with us Parul Khera, who is a petitioner, Ahmed Ayaz, lawyer, and Kamruzzaman Choudhary, leader of the Congress. Let me start, in fact, by asking you, Deshratan Nigam, is this the end of the road? Because if the carbon dating doesn't happen, then how will one ever find out what the structure is?
Padmaja, I'm getting a lot of disturbance and parallel commentary on this.
Sir, I will just have it fixed. I will just have it fixed. Sorry, my question to you was, is this the end of the road? If carbon dating doesn't happen, how will one figure out what is the nature of the structure discovered in the Wuzukhana?
Padmaja, in fact, I'll try to answer despite the disturbance that I have, that this has been refused on a technical basis. That technical basis is that the Supreme Court has already, given an order for protection of that place and to secure the area where the Shivling was found. Therefore, the trial court said, no, because of that order, I cannot interfere because that might affect the Shivling that was found. And therefore, this order has been passed. It has not been passed on merits. It has been simply passed because there is a pre-existing order of the Supreme Court. Okay. And therefore, the best way is to approach the Supreme Court and to have the order which the trial court has refused to get it from the Supreme Court. However, in the light of 20th May order where the Supreme Court clearly said approach the trial court and you can approach and file various applications. However, they said the first application that has to be decided was the maintainability of the suit. Okay. Under Order 7, Rule 11 of CPC. That application of the management committee of the mosque was dismissed by the trial court, and the court could have taken other applications and passed appropriate orders. However, the court, by way of abundant caution, on account of interpretation of the Supreme Court, has decided to not pass any orders and reject that application. And in that event, the only course left is to approach the Supreme Court, which passed the original order on 17th May 2022.
All right.
So therefore, I think that would be
this is only a technical hiccup, as it were, not even a setback.
Yes, certainly, because no trial court would try to pass an order bypassing Supreme Court.
Okay.
No. Rightly said. Rightly said by my fellow panelists. Yes, there is a technicality. It is based on certain technicalities. The order must have been passed on, and ultimately it has to go back again to the Supreme Court and see what exactly happens thereafter. But the larger point is, to get it, as it said, that to get it surveyed through scientific methods and all that, and see, these questions stand already settled as far as I'm concerned, because we need not to touch all these religious places, because there is already Religious Places Act 1947 in place, which has settled already all these issues, saying that there must not be any interference, any conversion done on religious places. If you go on doing it, then you'll have to, we don't know how many things will come up. That is why the reason behind getting a law enacted was to see that it is not opened any further after 1947, because you don't know. Today you are telling this place, Gyanvapi Mosque. Tomorrow there may be something else. Then there is no end to it. To see that it is put to an end, that's why the law was passed, and this is definitely a consideration before any court. It has to be a consideration before any court. Then there would be a Pandora box. So they will not like to see that the Pandora box is
old
open.
wounds. What will you gain? This will reopen past wounds. Parul Khera, can you hear me?
Yeah, Padmaja. Sorry, there's some audio problem. Can you please repeat the question?
Yes, we're having a bit of an issue today. Sorry about that. So, Ahmed Ayaz is saying that leave aside carbon dating, no carbon dating. Why do you want to reopen past wounds, old wounds, wounds of partition?
Still, your voice is not audible. Hello?
Right. That seems to be a bit of a jinx today. Kamruzzaman Choudhary, do you agree with that hypothesis that these are old wounds?
No, Padmaja, you need to understand, today we are speaking about something that has happened in history, maybe. I also don't know, you also don't know. Some 500 to 600 years ago or whatever it may be. Now, the point is that those violent incidents in the past, you bring them conveniently right now in 2022 and say that the present-day Muslims or those who are having religious places in dispute now in 2022 and say that the present-day Muslims need to pay for the ills that have happened some 400 to 500 years ago. This has to stop somewhere. Now, having said this, you know, this Aastha Jivis nowadays, they will bring anything to dispute and go to the court of law. One court will pass one judgment, another court will pass another judgment. You see how the gentleman, the ex-ASI director, he was coming in your channel and he was saying how he is prejudged about the structure that is there in the Gyanvapi mosque area, the Wuzukhana that we call it. So you see, there is always a biases in the judgment of people who will be listening to this, who will be judging on this. So it's better that we follow a cut-off date. That cut-off date was 1947. And 1991, we passed an act in Parliament which says that, okay, from now on, we will not be going into all those disputes and let those, there's Aastha Jivis.
So, Deshwatan Nigam, again, it keeps coming back to that can anyone put a cut-off date? Or, you know, people will keep oscillating between the district court, Supreme Court, Varanasi court. When does this end? This is an unending process.
Padmaja, in fact, it is my fundamental and legal right to know my history. And truth must prevail. This is not about opening the wounds. If the history is hidden and under the wrap, the only way to do is through scientific methods. Like in the Ram Mandir case, everybody opposed the deep penetrative radar studies.
Yeah.
However, things were underground and deep penetrative radar studies was undertaken. It was undertaken under a Muslim director, K.K. Muhammad, who very assiduously found out after through deep penetrative radar studies what was under the ground. So why people are afraid of the truth, I fail to understand. I have a right to know my history. I have a right to know my history.
Sir, let me just interject. I will take 10 seconds. We have got a right to know our history. But if those history, this thing hurts our fragile ecosystem, the balance that we are maintaining, the society is maintaining in India right now, do you agree that the Supreme Court judgment in the Babri Masjid case, wherein it said that though all documentary evidence are in favor of a mosque, but still then because of the Aastha.
Sir, you have not read the judgment.
You must read the judgment properly, sir. It's not the ASI report.
Sir, you have not read the judgment. It's not the KK Muhammad's report that only was the deciding factor in the Babri Masjid.
Having said that, sir,
let Deshwatan Nigam answer.
Let me answer you. You have not read the judgment. The Allahabad High Court judgment is the primary judgment, and the Supreme Court said that it is a non-Hindu, un-Islamic. In fact, they have used the un-Islamic structure underneath. They did not say about Hindu. That is where the Supreme Court is wrong, because there is a categorical finding of fact by the Allahabad High Court that has not been upset by any reasoning in that.
What are the observations of Ranjan Gogoiji, Chief Justice Ranjan Gogoiji on that judgment?
Let me tell you, that was authored by one judge.
Selectively,
it is a unanimous
from the judgment, and you misquote that.
Please
and
let me answer,
with another
sir. Let me answer. It has not to stop. It has not to stop. I have a right to know my history. The previous history has hurt my sentiments.
You have a right to know history, but do you have a right to correct history, sir? That is the main question
obviously,
that Indians ask.
Obviously,
that means declare it. No, sir,
obviously.
Thank you for accepting on television that you have a right to correct history. What Aurangzeb did 500 years ago.
Let me tell you one thing. Hold on. Hold your horse. Sir, hold your horse. Hold your horse for a second. Hold your horse for a second. Let me answer. Let me answer.
The minorities do not have a right in India.
Let me answer. Let me answer. This is not about minorities. This is not about minorities. This is not about minorities. Sir, this is not about minorities. This is not about minorities.
It is the rights of the minorities that is in question, sir.
History.
You cannot be biased and say that we need to correct history.
You had your say.
You have a right to know history. But
you had your say.
Okay, hold on a second. Let's also bring in Parul Kheda, who wants to come in at this point. Parul Kheda.
Hey, you are talking about, constitutional right. I just want to point out one thing. Article 25 of, Indian Constitution give us the right to practice and propagate our religion. So you can't take it away from us. This is our right, and we can, and that's our only, fundamental right, and we are asking for that only. So it's very simple, on 16th May 2022, we have found our Shivlingam. Now we are asking for the right, and we are very much sure that there are other visible and invisible deities there. So
Parul Khera, what about the argument that, today's developments have shown that this can go on endlessly? Carbon dating, no carbon dating. When will there be a resolution? Now from the district court, gone to Supreme Court, then some other court.
Yeah. I agree with you, Padmaja, because on 21st July, I myself have filed a petition in Supreme Court asking for scientific investigation, and then Supreme Court redirected us to the lower court. Now the lower court today is saying that please go to Supreme Court. There's an order which we can't, bypass, and you have to take a different route.
Yeah.
So it's like a pendulum situation there. We go to this court directs to the upper court tell us, but we will keep fighting unless we get justice. That's all I want to say. And one more thing here is that, hello?
Yes, go on.
Hello? Yeah. So my only submission is that, it is our right. We have asked for Shingar Gauri Puja. We went there. हम शक्ति के लिए गए थे, हमें बाबा वहाँ मिल गए. So now that we have found, and it's pratyaksh, it's very evident that it's our law, it's our very own Shivlingam. So why can't we have our right to pray? That's the only point.
Okay, is it reason enough to say that this is going to go on forever to stop people from seeking their basic right to pray? This is a setback. However, it is not the end of the road. Ahead on the channel, we'll also talk about what are the other options and how concrete they can be. For the time being, though, thank you very much, all gentlemen and Ms. Khera, for joining us.